Good morning, everyone. My name is Lisa Stutz, the Museum Director for the Royal Gorge Regional Museum and History Center. Thank you so much for joining us this morning for another of our virtual genealogy programs. This morning, our amazing volunteer, Terri Meeks, will be talking about researching probate records. But before we get started, we want to remind everyone that if you have any questions or comments you would like to share, to please type them in the chat box. We will be monitoring the chat box throughout the program, and we will make sure that any questions get addressed at the end of the presentation. One final note before I turn it over to Terri, it is to inform everyone of some upcoming events for the museum. On Saturday, February 5th at 1 p.m., the museum will be kicking off the city's year-long 150th anniversary with a free presentation on the geology that built Canyon City, presented by our Bureau of Land Management Paleo Liaison, Joshua Bouchard. And on Saturday, February 12th at 9 a.m., Terri will present another virtual genealogy program. This one will be on researching land records. Please follow us on Facebook and our YouTube account to get notices of our upcoming events and to see recordings of Terri's other genealogy programs. And with that, I will now pass it off to Terri.
Thank you, Lisa, and good morning, everyone. It's good to have you here with us. Just in case you're having any trouble viewing or hearing the presentation, you can use the chat box or send an email to Dan Meeks at dansmac711@gmail, and we'll make every effort to get you connected. So this morning, we're going to talk about probate records. Most of us go looking for wills in the hopes that we can find missing relatives or how an estate is to be divided. And this is all wonderful information. But from personal experience, I have found that if a person dies and owns property, if they die without a will, there might be even more information available for you. So we're going to start with a couple of definitions. What exactly is probate? It is a legal process, and it is to determine the validity and the authenticity of the will. And it is also the administering of a deceased person's will, or if the person died without a will, to validate their estate. Two of the other terms, testate, a person who has died leaving a valid will, and intestate, the person who has died without having made a will. And we'll explore a couple of other definitions as we go along. Some of the key things that you need to know when looking for wills. First of all, the name. Who is the ancestor that you are looking for, and what is the name that they might have used? What is their approximate date of death? The probate process may not have started immediately, so knowing the date of death, you can at least start from there and move forward in time. And the third thing that's very important is the county in which the death occurred. Keep also in mind that from your census research, you need to know all the counties where your ancestor might have lived. Did they hold on to a piece of property in another county or even another state? Because that then these other properties may also be subject to the probate. For early wills or estates, you also need to keep in mind boundary changes. If you're looking for a will or a probate case from the 17 or early 1800s, Know that counties changed. They subdivided over the course of years. So while it might have been Effingham County to start out with, it may have subdivided, and the will may have been in the newer county. So it's important to know the date when your person died and what was the county boundary at that particular time. And we'll repeat this a couple of times, but make sure that you understand that laws vary by state and also by time period. So when finding a probate set of records, what might they reveal? They might identify spouses and relatives. In the case where there might be more than one spouse, a first or a second spouse might be identified. And usually children are identified, but other relatives may also be named in the wills. You might also find the death of another relative in the will. If a son or daughter predeceased their father or mother, that might be noted in the will and might give you further information that you had not known in the past. Wills and/or inventories give clues as to how much property is owned, whether it's real property or personal property, where their residence was, and especially in the case of inventories, you can look and see the wealth of the person or the indebtedness. If there was a minor child, there will be paperwork for guardianships, who's going to take care of the interests of the minor child. And there may even be some records of adoptions. And one of the most interesting things is on a will, you're usually going to get the person's signature. And I have found it's really very, very interesting to get a will that might have been written in the early 1800s and see your ancestor's signature. So what kinds of records may be found within the probate packet? And we have quite a list here of the possibilities: wills, the appointments of the executor, and the letters testamentary. Those three documents will be found when a will has been written. If the person dies without a will, intestate, letters of administration have to be issued, an inventory taken, guardianships, and finally a final settlement. And we're going to look at each one of these records. When we realized that birth and death certificates didn't really come about until the 1920s, yes, some of them may have existed in some states prior to that, but in many cases they do not. So probate records and land records may be among the only official documents that your ancestor left behind. And once again, the state and the time period requirements vary. So let's talk about wills. We hope that one of your ancestors or many of your ancestors have left a will. And these papers direct the settlement of a person's property. And it's both the real property, land, and their personal property. What were the goods that they had? Keep in mind throughout all of this, whether it's wills or if a person dies intestate, they must have property, whether it's real and or personal property, but there has to be property involved. Wills usually first direct for the payment of any debts that might be levied against the estate. They are hand-signed, and in current days, they are witnessed. The witnesses in the good old days probably were family members, whereas nowadays it usually tends to be someone that's in the office. But it may include family members as well. And wills are dated according to the date that they are actually written. So some wills may precede the date of death by many, many years, or may be as close as a few days prior to the death of the person. Here's one of our first examples of a handwritten will. And this one, it's probably very, very hard to read, but it's written by James Smithson. And it says at the top, should my said nephew, Henry James Hungerford, marry? So in this case, we probably have a single gentleman because he's directing his estate perhaps to go to his nephew. He's also making provision in the case of the death of my said nephew without leaving a child or children, or of the death of the child or children he may have had under the age of 21 years or intestate. I then bequeath the whole of my property, subject to the annuity of £100, to John Fitch. And it's really interesting that it goes on to identify the United States, and he is leaving his money for the establishment of the Smithsonian Institution for the betterment of his fellow man. Here is another will from the state of Alabama, and it's from 1879. And it's a clear-cut will for the decedent, John Thomas Thrasher. And in the course of the will, he is leaving his real personal or mixed properties to his beloved wife, Martha L. Thrasher. But he is also saying he's making some additional comments. In making this my last will and testament, I am not unmindful of the children of my children, and do so establish the fact. I do hereunto annex their names. So he is actually naming off his 9 children: John W., Emera, Lillian, Ernest, Elizabeth, Olive, Philip, Alan, and Francis. So even though he's leaving his estate to his wife, he is also acknowledging each one of his children. Here's a will that's very, very current for Alvina Roloff. And we see that in the current context and form, she's acknowledging that any debts for our expenses for her funeral need to be paid first. There is the identification of her family, her son Jean, and her daughter Marie, and any grandchildren. There are grandchildren that exist for them. Her son also goes by the name David Solomon, and she has previously given her house to Marie Cheatham, her daughter. And there are special requests. She's leaving her personal property, keepsakes, jewelry, etc., to her daughter. So there's nothing unusual about this will. It is relatively straightforward, but it gives us the married name of her daughter. So when there is a will, the next thing that needs to be done is a letter of appointment of the executor. An executor may be named in the will, but this is paperwork that's going to prove that that person named in the will is in charge of establishing and handling the person's estate. And they have been given that duty. So the probate process involves, for example, a person being named as executor in the will. The will, depending on the size of the estate, must go through the probate process. The court appoints that person as the executor. If an executor is named, there still is a court appointment. Once appointed, the person, the executor, is going to receive a certificate of appointment and can then write letters testamentary. If an executor is not available, then an administration will be appointed. Here is an example of a certificate of appointment of executor, and much of the information has been blanked out, but we see the name of the decedent, the name, the date, where they lived, and their address, and that letters testamentary have been issued on such and such a date. Here is another form that is a petition for letters testamentary. And we see that we are going to probate the last will and testament for Verby Peaker. And the petition is being levied by Leanna Peaker and she is later identified as Verby's widow. And it gives her address at that point in time. And this is in 1925. It also identifies Sarah, Catherine, Emma, Robert, and Helen. These are all siblings of Mr. Peaker. And indeed, his wife is then given the letters testamentary to go forward in probating his estate. Here's another example from the 1879 timeframe, where Aurelius Depp and Frederick Litchford are applying for letters testamentary in the estate of Pleasance Litchford, who has died on April 2nd, 1879. There isn't going to be a death certificate at this point in time. So these documents are key and critical in finding out some of that information. In this particular case, we see the value of his personal estate at $350 and the value of his real estate as $15,000, a significant amount. Both Mr. Depp and Frederick Litchford need to file bonds in the amount of $800. Here again, they're only going to have to pay a portion of that sum, but it is to ensure that they legally go forward with the process of probating the estate and to make it true and valid. Some of the other names on Mr. Duffy, Mr. Littler, are another, probably a son, John Litchford, are named as sureties for the estate. And we also see three names, DM Sly, ZE Sly, and Willis Eakin, and they are being named as appraisers for the estate. So we have significant real estate as well as some personal property, and we want to get true and just values from these people, the appraisers, for the value of the estate. The letters testamentary are issued in the will of Pleasance Litchford of Ohio, and it is giving Frederick and Aurelius Depp the power to manage and administer according to the law, etc., all of the estate. Here's another handwritten one from the James Parker is deceased, and Samuel T. and J. Baker Parker are named as his executors. The will of the said county having been duly admitted to probate and record, letters testamentary on said will are hereby granted to Samuel Parker and J. Baker Parker, who have complied with the requirements of the law and are authorized to take upon themselves the execution of said will. Here again, July 3rd, 1879. So we've talked about the fact that if a person dies intestate, that an administration will need to be appointed. If there is no executor or the female executrix named in a will, an administration also needs to be appointed. And an inventory must be done to determine whether things need to be sold or whether things need to be divided among the inheritors. Here is an affidavit of death for Caroline Swanson, and it states that she has died without leaving a will. And John F. Swanson is certifying her death in February of 1910 in the particular county. And they have identified those people that have a right, perhaps, to a claim on the estate. We have Josie, who's probably a married daughter, John, who has certified the death, Augusta, Ella, and Albert. And we have their ages. They're in the 40s all the way down to the late 30s. And what is interesting in this case is Caroline has died without a will. And she really, it says that the following property, to wit, none. So she has no property. So why is there a probate process? Except that in which she held a life estate under the last will and testament of her deceased husband, Nels P. Swanson. We're going to talk about this a little later, but she has a life estate. She has exercised her dower rights, and we'll be talking about that. She has the right to remain on the land that was a portion of the land that her husband owned until her death. And now we are closing out the probate of his will because she has passed away. This might be a matter of months later or it could indeed be many, many years later that the probate is completed. Here is another case where Jefferson Johnson of Houston County, Georgia, has died intestate, and James A. Miller is asking to be appointed as the administrator of the estate to take care of everything and dispose of the property as needed. And he is given the full power to administer the lands, tenements, goods, rights, and credits of the deceased. And this is in 1860. This is another request in 1904 from the state of Missouri that Mrs. Dosha Cooney, widow of James Cooney, deceased. He has died without a will, and she is identifying all the people to the best of her knowledge that might have claim on the will. She includes herself and the relationship and where she lives. She has also identified Maurice Cooney, and he apparently is a brother, the 3 children of Michael Cooney, where they are, and they are nieces and nephews. And these people are deceased. So we've got the living nieces and nephews that are called out in this particular request. We have to take an inventory of the estate, and this will allow those administrators to determine the assets as well as the debts that might have incurred, the estate might have incurred. The values must be represent fair market value, and that's where the assessors come in. And it determines the total value of the estate. If a sale of the goods occurs, this must be recorded and is reported in the final settlement. So here we have the case of 3 gentlemen who have done the appraisal of the personal estate of Charles Snowden, and Aaron Thompson is the executor of his estate. This is from 1804, and Mr. Snowden apparently was extremely well-to-do. He leaves a ship by the name of Lydia, and the value is $6,000. And then humorously, he has 20 pipes of 4th proof brandy, and we get the value of that. 60 casks of claret, and its value. 79 baskets of oil. 40 boxes of fruit in brandy. Pickles. Cordials. We have 3 trunks of suspenders. And we have a gross of umbrellas. And again, more claret for a very, very sizable estate. So this is one of those cases where you do see the value or the level of wealth that a person might have accrued during their lifetime. For most of us, we see inventories more like this. This is a farm, and we're going to have a mare and a colt, and we've got some cows. We have sheep, we have hogs, we have bedding, we have bed quilts, we have 3 chairs. So this is more the what we are used to seeing in our own personal families. But it gives us an idea of what they have accumulated during their life and the value of each of those assets. Here is a final one. The return on the estate of Peter Barnett Matthews, late of Charleston, and he was a butcher. There is no personal property belonging to this estate except the following debts, to wit, balance due by the commissioners of the market for sale of butcher's stall, and we get a value for that. The balance due by William Lee for house rent. And a final note, Mr. Matthews, in his lifetime, purchased a pew in St. Philip's Church, for which he paid a part cash and gave his note for the remainder. It is now supposed that the balance due for said pew, together with taxes on the same, is equal to its full value, and the executor has signed. So we see some of the debts as well. Guardianship appointments are also filed in the probate court. And here again, as we've discussed, the person must have property. So in this case, an underage child is inheriting property, and a guardianship will need to be appointed so that that person, the guardian, can act on behalf of the child. In some cases, you might find that a parent is actually named for a guardian of his or her own children. And the guardianship gives control of the estate to that person. Here's a Rhoda Marshall, the widow of Thomas Marshall, and she is being appointed guardian for the personal property of Minerva, Cornelia, Martin, and Nancy. So and this is in 1870. Chances are these may be her own children, but they may also be nieces and nephews. From Illinois in 1881, we get a whole series of papers where Joseph Stroud, has died, and Daniel Palmer is applying to be the guardian of Margaret Stroud. It turns out that there was some property, and it has the value of $50. And Mr. Palmer is asking to be the guardian so that he can supervise that monies. Here is a record of the petition. Here again, Daniel Palmer for the estate of Joseph Stroud on behalf of Margaret Stroud, a minor child under the age of 14. She's only 13. And it describes how a portion of land has been sold and the value was $50, and he is asking for guardianship of that child so he can supervise the apportionment of that money. A bond here again is posted. Daniel Palmer, B.L. Palmer, and A. Lane, and Benjamin of this particular county are posting bonds so that they can carry forward on behalf of Margaret Stroud. And she is the minor heir of Joseph. And they each sign and have put forth a bond showing that in good faith they will act upon this estate. And finally, we get the actual letter of guardianship, the appointment of Daniel Palmer to be the guardian for Margaret Stroud. What is interesting in this particular case is that Daniel Palmer is identified in one of these pages as her stepfather. So Mrs. Stroud has remarried Mr. Palmer, and her daughter, Margaret, is now his legal dependent. We mentioned earlier about dower rights. These were instituted primarily in the 18th and 19th century to protect the wife. When purchasing land, the husband may have purchased the land solely in his name, so his wife does not hold title to the land. And it does work both ways. If the wife had purchased the property, then her husband would be eligible for this as well. And what this essentially says is that upon the husband's death, a portion of that land will be allotted to his wife for her protection. He may, in his will, have decided that his children receive that, but their mother is also automatically going to receive a portion of that land to sustain her. This was popular in the 19th century, but know that Ohio, Arkansas, and Kentucky to this day still have dower rights. Other states do have a similar structure, which we will also talk about. Approximately 1/3 of the state was left to the wife, and it was only during her lifetime. The important thing to know is she does not own the land. She is just allowed tenancy on the land. She cannot sell the land, but she can live on the land. During his lifetime, if the husband wanted to sell any part of his land, her signature was required to release her dower rights. And if she signed those away, she was not entitled after his death to any portion of the land. Dower rights, as described earlier, are actually called out in the will in the previous pages. This particular will also included a map, a diagram, so that we see the estate of I can't find it. Anyway, we see the estate of, I believe it's a John Coonrod, and he's leaving his son, Adam, his part, and his wife, Sally, has received the dower portion of the estate. So look for these records as well. And you get some additional information on them. Final settlements. The probate date is always going to be a date closer to the time of death. Initially, there was no time limit for when the probate process started or completed. Today, there is a time limit to start the probate process. Here again, know that the probate can last many, many years. It does not necessarily conclude within months or a short period of time. In some cases, they have to wait until the youngest child turns 18, or perhaps in the case of one of those dower rights, they need to wait until the widow actually passes away. So while the probate date may be closer to the date, the time of death, as opposed to the will, a will might be written in 1850, but the whole estate might not be closed out until, let's say, 1890 or even 1900. It's unusual, but it can take that long. The final settlement will name the relatives along with relationships and will tell you what monies or property that they indeed are inheriting. This is a case where the two people are identified, Robert Moore and Mary Moore, and they are each receiving $251.14 from the personal estate, and they are receiving it from Dosha A. Cooney, who was the widow of James Cooney, as part of the final settlement of his estate. And they're also getting 2 3/16 shares of stock in the Saline County Telephone Company. And the stock is being held by A.E. Cooney, and she is acting as trustee. Each of the inheritors is then signing their name to acknowledge that they have received their fair share of the estate. We also get another type of final settlement, and this is a case of a guardianship case. So there are expenses incurred by the guardian on behalf of the child. So any debts that might have to be paid or any sale of anything that might be received by the estate are also included in the final settlement. And this particular one states that the young man has attained the age of 21 years of age, and thus the final settlement is being signed and released. This is from 1864. If any of you happen to be doing any African American research, recognize that prior to the Civil War, enslaved people were considered property, and so they may be listed in wills. They may be given their freedom upon the death of their master or mistress, or they can be transferred to other family members or even sold to a third party. So wills in African American research are a very, very important avenue to investigate. This happens to be a listing of tradesmen, supposedly from George Washington. There's a GW up there. And it lists the names of each of the people from his estate, and goes on in the will for what is going to happen to each one of these people. In talking about dower rights, while that system has gone away in most of the states, except the 3 that we mentioned earlier, there are also affidavits of heirship, which are a similar structure. If a person owns property, but it's not jointly owned, and they die without a will, then they have to file for heirship property. title companies cannot issue insurance until the heirship has been established. Because of these forms, and I'll show you a blank form, there's a lot of family history information that will be included in these. They are signed under oath and they are filed with real property records. And here is a blank form where at the top you get the information about the decedent and when he actually passed away and his information. Then you see a listing of spouses, even if the person has been married more than once, each spouse will be identified. Any children from those and any deceased children, because there might be grandchildren that might be entitled to part of the estate. Their parents and any siblings. So it can give a very, very complete family history. So we've talked about these many different kinds of records. Where can we find them? Ancestry does have some of these records that are indexed, and they are for both the US and there are some overseas, especially in the British Isles. Family Search likewise has records in both the US as well as overseas. But in some cases, you might actually have to go to the state archives or the individual county courthouse to obtain copies of these records. Here's an example from the card catalog on Ancestry of the various states and the wills. The one at the top is for Missouri, and there were well over 2 million records. But we notice down at the bottom, Wyoming, we only see that there are 1,500 will records, will and probate records. So it's a catch as catch can on Ancestry. One of the good things is that these are indexed, so you can actually enter a name and information will pop up. Family Search has recently, in 2021, completed digitizing all of their microfilm records. They are not all indexed, so you may have to browse these records. So when going to Family Search, the first thing you want to do is search their catalog. And you want to enter the state and the county that your person might have lived in. When looking for these records, you want to consult the Probate Index first, and that will give you a volume number and page information to further look at. So here, for example, I use the Missouri Saline County, and here's the listing from the catalog of all the different kinds of records that are available for that county. At the bottom, we see that there are 4 topics that deal with probate records. And we see that there are probate records from this year span. The DAR has published certain kinds of records, and we have wills and a second set of will records for encompassing different years. So because this was one of the broader ones, I went to look for it. It does give a complete description about the data set, and there is a selection for how to use the collection. And we see that there are 6 million images that are not indexed, but are browsable. Don't panic. Missouri is divided into all of its counties. So we looked for Saline County, And when choosing that, we see that all of these different records are available. If the person had written a will in that time period, you can do a search for that. Or you've got the probate. And here again, because we don't know exactly when the probate was completed, we want to look first at the Probate Index. And this is one of the records from that. And we see that in the estate of Oliver Amesbury, and Mr. Crockett is the administrator of the estate. And we see that starting in August of 1867, all the way up until 1871, we are getting various documents with respect to the probate. The records are contained in different large books and with the relative page numbers for each of the actions. So I happen to look at these three documents that are on page 350 for convenience sake. And we see R.C. Amesbury, and she is the widow of Oliver Amesbury, deceased, of Saline County, Missouri. And she filed to relinquish her rights to administer the estate of her husband. And the second one is Mr. E.W. Crockett has made application for letters of administration in the estate of Oliver Amesbury, deceased, and that he has filed his bond, and letters have been granted, and there have been the appointments for the various things that need to be done to settle the estate. So this covers three of the records that were listed prior to this, but there will be other paperwork involved in the will. If you have to actually visit a courthouse, remember that courthouses are working entities. With the increased popularity of genealogy research and with the COVID, courthouses may not be open to the public for research at this time. You may have to actually go to the courthouse, fill out paperwork with your request for information, and they may, at their convenience, have to do the research rather than you being allowed to do the research, and they will send it to you. So just be aware that circumstances may be a little more difficult now than they had been in previous years. You also need to be prepared when going to a courthouse. You never know. It could be a very, very large room, or it could be very, very tiny room at the bottom of a circular staircase. But the records will be retained or in the county courthouse, or will be given to a state library or archive. There will be will books, and there will also be probate books. And just like we did with the example for family search, the first thing you want to do in terms of probate books is look at the index. So this one happens to be an index to the will books, and we see the date of probate for each one of these particular cases. They are in alphabetical order only by the first letter of the surname. So these are all S's. And it is arranged according to its, whoops, excuse me. We're going to send you to a book number and a page number, just as we saw previously. In some cases, you may be directed to files, and you will actually find a folder of a similar description that contains all of the documents associated with the probating of the estate. It may contain the will. If there was no will, it will contain the appointment of the administration, the inventory, the final settlement, all of these documents. So be prepared. You just never know what you might find. So with that, I will open it up to any questions that you might have.
Well, Terry, we don't have any questions today, but remember back one of our genealogy trips to Ohio and going through probate records, and just like you had the picture of the lady with the drawer and the envelope and everything, one of my ancestors in the probate records had an IOU. And what was so special about that for me was the fact that it was in 1803 and it had his signature. So to see my ancestor's signature just brought it back to life, even though that it was a long time ago. So these probate records have treasures of information. And I remember looking through one of your probate records of an ancestor and seeing from the drugstore the list of items that were purchased, and then of course the inventory of the household items. It tells a story about the individual, and that's priceless too.
Yes, I totally agree. You never know exactly what you're going to find. There may be copies of marriage records as well in probate records to prove that a marriage was viable. And sometimes those little tidbits of paper, those little slips of paper with the IOUs or other information are particularly interesting. One of the other things that I recall in looking at some of the records that I have found, for example, on the one for Dosha Cooney, it named 3 children that were the children of one of my Cooney relatives. And what you couldn't see in the thing was that there were 2 sons and a daughter, and he was deceased. Well, number one, it tells me that as of 1908, their father was deceased. I did not know that information. The other clue that they gave me was that the information that Dosha Cooney had at the time said that the 2 sons were in the military in the Philippines. This allowed me to prove heretofore information that I had gathered but had not been able to associate with the various lines in the family. So I see that we have a question.
Well, not so much a question, but a comment says, one of the viewers said, "This has been so educational. Also, I am super excited to see how many records are available on Family Search for Missouri. A great number of my family ancestors lived in Missouri." Thank you so much, Terry.
So, well, you're most welcome. That's the whole point of some of these classes. We hope to either familiarize you with some of the information that is available, as well as give you the clues and the hints as to what might be out there for you to find. As Lisa mentioned earlier in the introduction, next month, we're going to talk about using land records to look at some of our family history. And know that approximately 90% of the people in the 1800s bought or sold land. So chances are there is a record for you somewhere among land records. So I want to thank you all for joining us this morning, and I look forward to seeing you the next time.